Okay, we'll continue with our 1:30 arraignment docket. Want to do your cases, Mr. Medina?
Happy to, Your Honor. I know they're going to be not guilty pleas based on discussing things with Assistant State Attorney Sharpless later in the day. My out of custody, it looks like I only have two that are currently assigned to the public defender, maybe three. Ashley Cook.
Okay.
Ivan Iriguin. Christopher Evans. Mr. Evans is approaching, Your Honor. Could we defer the other two and see in case they show up in the next few minutes?
Sure.
Mr. Christopher Evans is before the court, docket number 12, 23 CF 1601. I'm not sure if he's filled out his application for the public defender.
For Mr. Evans, I already have one.
Okay, good.
I'm just starting to get to the case.
Yes, and he's been appointed, so. Did the application show that he was appointed now?
My docket says you were appointed.
Okay, I am showing that the public defender was appointed at first appearance.
Do you have an application approved by the clerk's office?
No, sir.
Okay, so, Your Honor, if he could enter a plea of not guilty for Christopher L. Evans Madison in 23 CF 1601, and then on the way out, if he can make sure to fill out the application with the public defender and turn it into the clerk's office before you leave the court today, okay?
And our next hearing will be October 9th. Okay.
And I'm giving him my card.
Meet up with your attorney.
Mr. Bailiff, can we provide him a copy of the application? And then they'll let you use one of their pens that's on the first floor. Okay.
Then turn it back into your turn.
I read through the entire arrest report and there's not one in there.
Oh, okay, thank you. Your Honor, I'm informed that Ivan Regatta Ariguin is in custody in Escambia County Jail. I think we probably need to continue his arraignment. Do you have any information as to date of decision or anything like that?
He's being held on a no bond for probation violation. According to the jail website.
Not guilty, please, Steve.
Your Honor, we'll probably do a not guilty, written not guilty plea and take him off the docket that way. But for purposes of today, can we just get him a new arraignment date?
If you're going to enter a written not guilty plea, why don't we just go ahead and put him on the next pretrial?
Okay.
And then we'll say as an inmate, 10-11, you can file the not guilty plea.
Yes, Your Honor, I'll make sure we do that. Thank you.
And Mr. Medina, I'm looking down at the docket here, I realize we have several defendants on the arraignment docket that do not have attorneys. So if you're through with your out of custody before you do your in custody,
Oh, of course.
I'll undo the ones with that.
Of course, Your Honor. Thank you.
So,
I have the inmate that's unrepresented ready for you to go to.
okay, now, which one is that?
That's going to be Tracy Brown, according to my report.
That is correct. You want to bring him out now?
Sure.
And Mr. Medina's taking off.
To the list.
Right, yeah. So just come to the podium, sir.
Yes, sir.
So would the state go ahead and announce the case?
I'm sorry, Mayor, I don't think we.
23 CF 1623.
Doesn't look like this.
This is a
There should be.
out-of-state fugitive from justice case.
And yes, Your Honor, there is no information filed by the state. There's generally not in these cases. I think that there is still 30 days left in the time for this other state to come get him. So if we can kick this to the next
Do we need to appoint him an attorney? No, not until. Generally, we don't appoint him.
Generally not, Your Honor. I don't know, I don't have any information about any governor's warrant. If I have that, I'll let the court know at the next arraignment. I haven't heard of any.
Where's the
I feel like it was,
warrant from which state?
I feel like it was a northeastern state, but I could be wrong.
It's Arkansas.
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 Definitely not a northeastern state.
Your Honor, does the court wish to give a control date just in case?
Yes, absolutely.
Yes, that's what I would suggest, Your Honor.
Yeah, you want to come back in a month or so?
May I speak?
Sure.
So I was arrested on this warrant from Arkansas. It's I had actually got people. I signed for extradition 30 days ago already. I set 30 days, and I've had family members contact Arkansas to see if they're coming to get me. Arkansas said that they are not likely to come get me, and that I just need to report to Arkansas and try to get it handled as soon as possible. I have set over 30 days. I got arrested, I believe, Friday the 20th. I went to first appearance on the 21st.
Hold on. State? What happens if he's been?
So, Your Honor, my understanding is if he has agreed to be extradited, they have, I believe it's 60 days to come and get him.
It says 30. It said 30.
Generally, it's 30, but
Is it 30?
Mr. Gates, any input on this?
It said 30 on the
60 or
paperwork I
30? I thought
signed.
it was 60.
Typically, it's 30 days, and then there's about a 15 to 20 day extension that they can ask for. I usually say
Well,
it's
who
about
would
40
ask for it?
Usually, it's the state of Florida will ask for an extension if they haven't heard anything. But I know the jail was very adamant. Like if they, the second they can let them go, they let them out the door. They don't want to
Yeah, I
hold them
know.
for another state.
Yeah. So what do we need? I'm just trying to figure out what we need to do here today.
I would put him on another day for patrol, and if he gets extradited, it comes off the docket.
Sure.
Your Honor, could we maybe put him on an earlier rather than waiting until October or something in
Sure.
September?
I can put him on another arraignment.
September the 12th.
But September 12th is the first one I have after today.
May I ask a question?
Sure.
Because I know when I went on that piece of paper that I signed, and everybody I've talked to at the jail, they said, speaking about guards, because I have been asking about this, and I've had people calling from the outside to Arkansas and trying to call the jail and stuff. And to my understanding is they have 30 days to come get me, and if Arkansas does not ask for an extension, you know what I'm saying, normally what they do, because I have been through this, they release me. I set 30 days. I've been at the Jada
I
house.
understand what you're saying. I heard.
I'm just ready to get out and get
I
my
know,
stuff
I
back
know.
on order. I want to
I
take care of this
understand.
as soon as possible. I'm not trying to cause no grievances with
I
anybody.
understand. But unless somebody, that's why I'm trying to get some direction from the state.
Your Honor, I mean, it's, the state of Florida is not the requesting jurisdiction, so normally we just hold them as a courtesy. I don't know that state of Arkansas would have to ask for an extension, so
So have they? It's been 30 days.
I have not seen a governor's, we don't need a governor's warrant, obviously, because he signed.
So here's what I need to do. I understand.
It looks like it looks like the 30 days is up here in the next week, Your Honor. I do see that Mr. Brown signed for probation, 3 years of probation, like 3 months ago.
So here's what we're gonna do.
I signed.
Stop.
Yes, sir.
This Thursday, we have, in the afternoon, we have an arraignment, not an arraignment, we have a miscellaneous in the afternoon. We're gonna come back Thursday afternoon. I need the state to get some direction about what needs to be done and how long we need to hold them. We don't wanna hold you any longer than you need to be held either, but they've got to make it. Unfortunately, I can't rely on counsel of the jail.
Yes, sir. May I just ask one more question? Does anybody know where the paperwork is that I signed the Friday or the Saturday of my first appearance with Okaloosa County?
All the paper that you signed is in the computer. confused.
And it should have been extradition papers signing for my extradition rights, right?
Right.
I'm just asking because I want all the dates and stuff to be clear with that because it has been 30 days. No extension has been asked for. It says that there's no.
You're doing a great job advocating for yourself, but we need to figure out what's going on. We're gonna come back in 2 days. We're gonna get some direction from the state, exactly what's going on with Arkansas, how long it's been, et cetera, so.
He
Okay.
signed, I will say the court, he signed it on July 22nd, 2023.
Okay.
Your Honor, may I, as a friend of the court,
Sure.
This is best efforts here, but my understanding is that if there has not been a recommitment order by the court for a further period not to exceed 60 days, that whenever that initial period runs, he should be discharged. So.
That's right, and 60 days hasn't run, and that's consistent with what the state attorney's office just said.
Well, the initial period, I'm not sure what that is, but without a recommitment order, I think it's just the initial period, which I think is 30 days.
Okay. Somebody's gonna have to give me some better thing. We're gonna come back in 2 days and review it, try and get some clarity on it. No, I'll get some clarity on my end.
Typically 30, and you have the extra lines that has to do with the extension.
Okay, Samantha Blair Incorporated. Come to the podium. Right, and if anybody else is here for an arraignment, listen to what I'm about ready to tell Ms. Blair. You're here without an attorney at this point. This is case number 23 CF 1583. This is your first hearing. The purpose of today's hearing is just to make the plea. Guilty, not guilty. But importantly, you do have a right to have an attorney appointed. So I'm going to ask everybody to, if they wish to have an attorney appointed. That's my first order of business. So are you planning on hiring a private attorney, or are you going to wish to have an appointment with a public defender?
I need a public defender.
Okay. So I'm going to appoint the public defender, and I'm going to enter a not guilty plea on your behalf.
Yes, sir.
And the purpose of that is to preserve your rights. You don't lose anything by entering a not guilty. And you get a chance to meet with your attorney, and then we'll come back on October 9th to your pretrial.
Yes,
Okay? So make sure to fill out that paperwork before you leave.
Yes, sir.
Okay?
Turn it in on the first floor.
Okay.
My card with my assistant's name. Here, approved as a public defender by the clerk.
Robin Cook.
Your Honor, that's the case that I emailed the court's judicial assistant about the other day. Mr. Cook did show up at the last arraignment. The state had not filed information because we had not received the certified driving history. And information has been filed in Mr. Cook's case. Mr. Cook and I did speak, and there was a plea and abstention that we worked out. He did he lives in Texas now. He is stuck in
Is
Texas.
this Robin Levon Cook?
Yes, sir.
Okay.
And he's stuck in Texas now, so I was going to ask if we could pass it to give him time to send me back to plea and abstention with his fingerprints.
So
And
you
I
want
think,
to come back on our next arraignment day?
Yes, Your Honor.
September 12th?
yes, Your Honor.
So we'll continue this arraignment until September 12th.
And I do have an information in the case.
Yes.
Yes, that's correct. Okay, Christopher Day. State?
Your Honor, I don't see Mr. Day present and approaching. This is 23 CF 1599. I will tell you that this is a case that there is some information the state is still waiting on to make a charging decision. I do expect that this will be taken over by a special prosecutor with my office, but I don't see him present today, so I don't know how the court wants to handle that. The state would ask for a capias, so I believe he was noticed for today's hearing.
He was properly noticed for will issue a capias. Yes. Espino? Espino. No. Would the state announce?
Yes, Your Honor. This is 23 CF 1485. Your Honor, the state does have...
1485 or 1483?
1483, I'm so sorry. 1483, the state does have an offer that he might want to consider. The state has filed driving while license suspended with prior convictions. The state is amenable to him pleading to misdemeanor driving while license suspended or revoked for credit for time served, Your Honor, if he wants to take that today.
Do you understand what she said?
I think, well, I'm not sure.
Okay. Why don't we do this? You do have a right to have an attorney appointed,
Yes, sir.
and you wish to have an attorney appointed? Yes?
I do.
Yes. I'm going to appoint a public defender, and do you know which one who would handle? Steve, does he need to fill that out? What I'm going to suggest that he does is have a 5-minute conversation with one of you all, because I think you could explain
Yes,
it.
let me talk to him, Your Honor. He may want to come back up.
Okay.
Thank you.
Is Brooke Etier? E-T-I-E-R. State?
Your Honor, the state will ask for a capias in this.
Or list you have no bond state? Okay, that's all the out of custody without an attorney. Mr. Gates, you want to do a couple of out of custody? You've got a couple.
Yeah, I did, on my list, I have a Donald Fowler that was unrepresented. That was gone to Sean Mapella, so we're good with that, Your Honor. My two were here, Your Honor. I asked the state if we could waive their appearance. The state agreed to it. Miguel Johnson.
Okay.
At this time, Your Honor, we're going to enter a not guilty plea on Mr. Johnson's behalf. He is scheduled for October the 9th.
Very good.
And then Deborah Krauser was also present. The state agreed to waive her presence. We'll enter a not guilty plea on her behalf, and she's currently scheduled for October the 9th, Your Honor.
Very good. Okay.
It's all my out of custody, Your
Or
Honor.
Mr. McGee?
I think he's outside talking to somebody.
To the person
You talking to him?
okay. Come on back, sir. Look.
So did you get a chance to speak with him a little, to understand a little
Yes,
better?
I do understand.
What the,
Yes,
what
yes,
the
sir.
offer was?
Yes, sir, I do understand.
Do we need to put this in writing, Ms.?
Your Honor, I don't have something written up right now, but I can. Technically, it's a misdemeanor, so it could be oral if the court would accept that, but I will write it up if that's the.
That's fine. If it's a misdemeanor, we'll allow it to be oral. So, say the offer again, make sure.
So, Your Honor, currently, he is charged in 23 CF 1483 with a felony DWLSR with prior convictions. The state is willing to let him plead to, instead of the felony 322.34 2C, the state is amenable to him pleading to 322.34.
You're saying a lot of Okay, where I can absolutely assure you, he doesn't have a clue what those numbers are.
I'm trying to give the clerk
I ain't got, you're putting it on the record, but you also
Yeah,
have to explain.
I'm suggesting that he would plead to the misdemeanor instead of the felony, and he would get credit for time served.
Okay. That
With the
means
court costs.
you'll get court costs applied, credit for time served, there'll be no probation, no further out.
Yeah, I'll definitely take
You
that.
wanna do that?
Yes, Your Honor.
Okay.
And Your Honor, the adjudication would be adjudicate guilty, and if Madam Clerk wants me to give her the misdemeanor statutory reference.
Did you
Under
get?
322.34, I was following you when you were initially.
Yeah, I'm sorry. I didn't throw it right in there.
Okay.
Did
So
you
it
get
would-
that down?
It would be instead of 322.34, and I think it's, right now it's charged subsection 2C, it would be subsection 2B.
Thank you.
Is he gonna get some kind of documentation that says exactly how much he owes, from this, an order on this?
I would do a
This-
disposition order and send it to you, you sign it, and then it's sent.
Okay, so you're gonna get some paperwork that'll tell you what we did here today, credit for time, it'll also tell you how much.
Yes, Your Honor.
What did the court cost him?
If she wants, criminal traffic, it'll be 300.
Yeah. Okay. It'll be three. Okay?
Yes, Your Honor. Thank you.
Any questions?
None whatsoever, Your Honor.
Okay. Thank you very much.
Thank you. Thank you.
Is there a time frame for him to pay
Oh,
this?
sir, I'm gonna get your fingerprints. This is just saying.
180 days, Judge?
Yes.
So they can see your twin brother.
Okay, Mr. Dean, you want to do your, I don't think you have any more out of,
Yes, Your Honor, I can take my in custody. I've already discussed them with the state enough to know that we're just going to be entered in plea of not guilty. Baker was the first one I knew of, but whoever the,
Yeah.
my part of the alphabet, I'm happy to take, because I'll probably be assigned.
Oh.
A through E.
Oh. I guess. There you go.
I put all of her evidentiaries on with the plea day today, so they're continued, and a not guilty is on Ms. Baker, is that what I heard?
I don't know anything about Miss Baker. She hasn't been out yet.
yeah, but you said something and she heard. That's all right.
I'm sorry.
You guys just,
I'm sorry, I don't remember what that was.
so they were all plead not guilty.
Oh,
That's what you heard. That's all right. Go ahead. Announce the case.
well, they're still coming out. We'll individually
They are,
announce.
they
I'm
are,
just
they are.
letting the court know. Steve Medina with Jenny L. Baker. Her new law case is, I guess it's 23 CF 1636. And then she's got VOP cases, 22 CF 2998, 23 CF 712, and 23 CF 713. And she would deny the VOPs if they're on the docket for today and plead not guilty to the new law. And remains or be set for October 11th. And was there an information for us to be able to
I
plead
just
not
handed
guilty?
it to her.
Okay.
I was gonna hand it to you, but you're.
Okay, so we're okay to plead not guilty.
Very good.
You're not getting.
You want to talk to her?
Sure. Yes, ma'am.
Stephen Bayshore should be next. You can go in order. Bayshore?
information. Is that at the lectern there next to your attorney?
Do announce the case.
Yes, Your Honor. Steve Medina with Stephen Michael Bayshore, 23 CF 1582. He will enter a plea of not guilty.
Very good. Court will enter a not guilty plea on his behalf. Come back on October 11th on pre-trial.
Thank you.
Thank you, Your Honor. Thank you.
You know, this is Mr. Crumholes before the court.
From Holtz.
Yes, Your Honor. It should be 23 CF 1642.
Very good.
We had intended to enter a plea agreement to cover the case before the court. It sounds like there is a pending misdemeanor with the DUI that was associated with this case. My expectation was that that was going to be resolved this morning. It actually sounds like they're intending to transfer it up to the felony case number. After speaking with the state, we're going to bring Mr. Crumholes back on Thursday with the intent to try and resolve all the cases at the same time so that we're not trying to piecemeal together later.
Let's come by, let's come back in the morning, in the afternoon, and pretty hard.
Yes, sir. And it should be a plea to probation, so he'd be released that day.
24th at 9. Thank you. Thank you. Mr. Medina, all I've got is meeting on the arraignment.
Mr. Emery? Right, Emery, we've got an agreement that I haven't sent back to him yet. The state has to look at it. Can we hold Mr. Emery to the 2:30? I've provided the state a proposed agreement. I'm sorry?
What?
Mr. Emery was on the morning docket, and we carried him over. I think we're going to be able to get a global resolution.
Okay, very good.
And we just...
That's fine, that's
need a
fine.
few minutes.
Losing track of all my cases.
I apologize.
That's all right. We've got your 2 out of custody that were no-shows on
Right.
First one is Ashley Cook, 23 CF 1645.
Okay.
She knows.
Ashley Cook, I have no information on her.
And we do not have any information on that.
Could we get a new court date?
She knows. State,
Is Madam Clerk stating that there is no information?
no information filed.
There is no information filed because that's a case where we're waiting on the certified, it's a new case, we're waiting on the certified driving history from
Right.
DHS, the DMV. I have no information about Ms. Cook, Your Honor.
Good,
What
but
are you asking the court to do?
Issue a KPS?
I have no basis to respond to that.
I'm going to issue cases, you got to show up.
EIT,
Okay.
or ETI.
How do you pronounce your last name? I-tier?
E-tier.
E-tier. Would you come stand at the podium, please?
Yes, sir.
This is a no attorney, Mr.
Yes, Your Honor.
Medina. With the state announce.
Yes, Your Honor, this is 23 CF 1577. The state has filed an information in this case, and this is likely going to be a probation case, Your Honor. I do not think Ms. Etier has been on probation before, so I don't know if I need to stand here and let her know what the state's offer is, or if she's going to want to speak to a lawyer.
Don't talk about the factual case.
Yeah, don't talk about the
No,
fact.
but-
Are you, so, the first thing I would normally do, and which I'll do, is ask you if you want to have an attorney. And the purpose of today's hearing is strictly to enter a plea, not guilty. In this case, you'd enter not guilty probably, and so that you have a chance to talk to your attorney.
Yes, sir.
The state is making an offer just to kind of short circuit everything, because of probation, but I don't have a problem with appointing an attorney if you wish one. You can talk with them, maybe talk with them today and get a resolution.
I actually have an appointment with an attorney. He wasn't
Okay.
able to see me prior
You
to
want to hire
today.
your own attorney, that's fine.
Possibly, yes, sir.
Oh, so why don't we do this then? The court, I'm going to go ahead and enter not guilty, assuming you want to
Yes,
enter not guilty plea, right? And we'll come back on October 9th at 9 a.m. for a pretrial.
Okay.
But in the meantime, you got to get your attorney, you got to meet up with him. Don't, try not to show up, you got almost a month and a half before you come to your next hearing.
Yes, sir.
Okay,
My
so-
appointment is with him on Monday. He's just happened to be out of town.
That's fine, that's fine. Okay, so October 9th, 9 a.m.
Okay, thank you.
Okay, thank you very much. And the court will withdraw the cases. Okay, I think that's all we've got for our arraignment docket.
I have all the inmates for the 2:30 group, if anybody's ready on that. I don't know if it's going to be.
I haven't had a chance to talk to Mr. Case or Mr. Clue. I do need to.
We've got Mr. Brooks here.
Yes, sir.
Mr. Brooks. So we've got that, his client's actually the first up today.
We have a motion for bond modification scheduled for today.
Correct?
My client, as he approaches. Your Honor, we're asking the court to approve a modification of the bond to remove the GPS device for various reasons. One, he is still employed and he's working shutdowns in the local facilities that he's shutting down. And on
What is
occasion.
Shutting down, what do you mean shutting down?
I work for International Paper. I work for Austin Industrial. I work at International Paper in Canton, Florida.
Okay.
They're
You're shutting down what?
every time turn around, we have to go in for outages. What they call power outage. It may be Saturday, I had to go, Sunday morning, I had to go in for a fire.
Okay. Okay, go ahead.
And my understanding is he has to go inside boilers on occasion, Judge. And because of that, it's setting, they're getting an alert that they can't get through to him with the device. That's one of the issues. The other issue, one of the other issues, Your Honor, is that this device was put on presumably to protect the victim in this case, and really there is no victim in this case except for perhaps the state of Florida, because it was a
You're making a rash assumption about that, counsel, but I'll let the state address that, but.
I mean, they can of course argue that there's.
I'm pretty sure that's not gonna be your argument.
It's
She's trying to protect
exactly.
the person.
What I'm saying is, if the reason is to keep it on, it was a law enforcement officer that he
I
was talking
understand.
to. And so, right now, it's prohibitively expensive for my client at this point in time. Prevents him from moving around without going great distances to contact.
Well, we have an alternative. You know what that alternative is?
Well, I know what you're going to say, Judge, but it's,
I mean, GPS is an accommodation.
he doesn't
Anyway,
have,
I'm arguing to stay, I'll let stay.
that's fine, Judge. I understand that. What we're asking the court to do is just to modify this, to take this off. He's local. He's been local for a long, long time. He's got family that lives in the area. He's got a dad that lives in Mobile that's not doing very well right now. He'd like to go visit him. It's causing him a lot of difficulty at this point. And we've just started getting the discovery. We have depot set for August 4th. In this case, he would like to be able to do his job, make money to take care of all the bills he's got. And
So
also
if you're not been able to work because of.
I'm working, but even if I was working in the recovery boiler, per se, they get what they call shielding, and they keep, every time I go in, they want to check my mind. If I'm upstairs in the 8th floor, which if you walk upstairs, it's 100-something degrees up there. Inside that recovery boiler, there's nothing but steel. and it goes on and on. You can feel it vibrate, or they're not catching it. And I have to walk all the way back downstairs, walk back outside for it to get a green light again, and then go back up into the recovery boiler to go to work.
And that's basically the argument, Judge. Go ahead.
I'm sorry, Ms. Lawson.
Your Honor, as the court is aware, the state will be opposed to removing the monitor. It is for the protection of society and the children in society. Fortunately, it was an undercover officer, but I would point out to the court that the defendant thought, and actually admitted, that he thought he was talking to a 14-year-old. These were extended chats over a period of time. They were very detailed, very explicit as to what sexual acts he wanted to engage in with that child. He even asked her for a picture of her shaved pussy. So it was very clear that he had an interest in children, and that really, Your Honor, is what we asked the GPS to remain in place for, so that we know that he is not in areas where there are children. We know where he is, we know what he's doing. Your Honor, as far as the difficulties with the job, something as simple as a call to his monitoring officer, if he is called out where he has to go into the boiler, to let them know, hey, I'm going to be in doing this at this time, that can later be verified. That he was out based on that, that's not an issue. They will work with them. Pretrial services can be accommodating, but we do believe that the safety of the children, the safety of the community is paramount and more important than the convenience to the defendant, so we are asking that remain in place.
I have to agree with the state. And the purpose of these are not to protect against the undercover officers, protect against other members of the community. The purpose of bond and bond conditions is twofold. One is to make you come back. That's the primary one. I don't think that's a big issue here. I agree with you. You're a local guy. You probably aren't going to be running off. You got a job, etc. But the other part that comes into play is safety of the community. And in this case, this is a very standard condition and an appropriate one. So of course, I'm going to deny the motion.
Thank you, Your Honor, for hearing the case.
Thank you, Your Honor.
Somebody will get me an order. I appreciate it. Okay. Mr. Gates?
Yes, Your Honor. I'm going to take a couple of the shorter ones.
Okay, Your Honor.
This is Ryan Jackson before the court in 22 CF 2462. We have a plea agreement to be filed. This was originally set as an evidentiary hearing, Your Honor.
Okay.
What's the last name?
Jackson. If you have no objection to the score sheet, may I approach? Thank you, Governor.
Will you please announce the agreement, counsel?
Yes, Your Honor. At this time, Mr. Jackson will be admitting the violation in case number 22 CF 2462. Recommendation is going to be adjudication of guilt. He was previously adjudicated, revoke and terminate the supervision, sentenced to 9 months in the county jail concurrent with credit for all time served. Standard cost of prosecution, public defender fee. Mr. Jackson's asked the court to allow him to have 24 months to pay those before they're sent to collections.
state?
That's correct.
Very good. Mr. Jackson, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement, correct?
Yes, sir.
And those same terms are contained in the written plea agreement. Have you read the plea agreement closely?
Yes, sir.
Judge, I should just say on the record that I did attempt to contact the victim for her input this morning. I've been in contact with her as we were approaching the evidentiary hearing. We did come to this agreement this morning. I reached out to the victim. I have not heard from her, but I did let her know in my voicemail that I was expecting the evidentiary hearing to be canceled, and she's not here, so I do believe she got my voicemail. So for
Was
that
she
reason,
anticipating being here for the
yes, she was.
evidentiary hearing?
Yes, Your Honor, she was.
So the fact that she's not here, you're making that assumption, the fact that she didn't call you back?
That's correct.
Okay.
So I do believe at this time that I've complied with Marcy's law.
Okay, very good. Thank you for outlining, that's important.
Thank you.
So, Mr. Jackson, I just want to make sure you've read this plea agreement. Have you gone over it with your attorney in
Yes, sir.
detail? Be sure you understand what
Yes, sir.
all the legal ins and outs. Have you had all your legal questions answered?
Yes, sir.
Understand you're waiting right to go to a final hearing. We actually would have one scheduled today.
Yes, sir.
You're waiving that right in order to have a final resolution of this matter.
Yes, sir.
You believe it's in your best interest to do this?
Yes, sir.
You know, have any other question? Nobody forced you to get you in or anything?
Oh, no, sir.
Based upon that report, let's accept your plea agreement and will, you've been previously adjudicated guilty. The court will revoke and terminate probation, sentence you to 9 months in the county jail. You will get credit for all time served. That's for each of the charges. They will be served concurrent, so it's basically a single 9-month incarceration. There'll be fees and costs that are contained, but you'll have 24 months when you're ready to pay all outstanding court costs before it's sent to collection.
Yes, sir.
Okay?
Yes, sir.
Thank you. I need to take just like a 2-minute break.
Okay.
All rise. We're in our recess.
Oh, it's funny because he left and then I didn't see him go out. And then he got lost between there and there.
Oh, right.
He just paused for a second.
Yeah, so she essentially.
Oh, it's
Yeah.
much worse than that. It's
Yeah.
even worse. You should
Oh,
see.
Hey, Kevin,
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 Ken,
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 Ken.
Ken, what were they saying? What were they saying online after she said that?
Oh, I said all kinds of stuff.
No, when she said that.
I said that. I didn't say anything about the language. There's one lady that's been going on about the pedophile.
Uh-huh.
There's nothing bad. She just didn't know what that meant.
All rise, court is back in session.
I didn't hear it. There was nothing bad.
Paying attention back there.
Please be seated.
Antonio Gray?
Your Honor, this is Mr. Gray. This is set as a sentencing, but I'm anticipating a pretty quick sentencing, mainly argument.
Okay.
Yes, Your Honor, I think we'll just go straight to argument.
Very good.
Your Honor, Mr. Gray's before the court in a violation of probation. He's already pled to the violation. Incorporated in the violation report was a charge in Jackson County, grand theft auto. The score sheet here indicates that Mr. Gray actually scores roughly 39 points, and it may have gone up to
It went up to 41.6 points.
41.6 points, Your Honor. I'm asking the court to sentence Mr. Gray to a county jail sentence. The court's aware the legislature designed the score sheet to kind of give us guidance on what is an appropriate sanction. Mr. Gray does not score to USC. I think a county jail sentence would be an appropriate sentence for Mr. Gray. He's specifically asking for 9 months county jail. I will tell the court, during my conversations with him, he had about 30 days prior credit before he entered the plea, was out and violated, came back, was placed on community control, if I remember correctly, and a withhold, and then subsequently picked up on the charges in Jackson County. He was arrested in February, if I remember correctly, and actually sat in jail there. And if I can, I want to show the court the minute sheet on that. It basically, at the very bottom, when he was picked up, it basically says that we haven't filed a warrant and they were going to let him on out. Fortunately, he didn't. He's stayed in custody since then. Entered a plea in May to 2 years of probation with court costs, restitution of about $500, and then was transported over. Essentially, this is the longest he's ever been incarcerated, Your Honor, from that February date to now. He's never been incarcerated that longer. Outside the charge in Jackson and the charge before the court, it's a misdemeanor criminal history. I think the court should do a county jail of the sentence in the situation. I can understand if there is a significant criminal history in a situation where someone may or may not catch a break because their prior history isn't lengthy enough, but the charge is determined, hey, situation where someone needs to go to prison and they don't score it. Mr. Gray, I don't think is in a situation like that. I think in this situation, given that he really hasn't been incarcerated very long in his criminal history other than what we've got now, a 9-month county jail sentence would be appropriate. He would still have a couple months left to serve. He does have probation that he's got to handle when he gets out, so I don't necessarily want to delay him starting on that, especially with the restitution issue. So we'd ask the court to consider doing.
How long is the probation?
It's 2 years, Your Honor.
Following?
Once he walks out of jail or wherever the court determines, he's got 2 years of probation. He's got to start immediately upon release.
Counsel for the state.
Judge, I respectfully disagree with Mr. Gates's position that 9 months is appropriate here. I'd like to walk through the defendant's criminal history, starting with
Let me ask you this, do you have a score sheet?
I do, Judge. May I approach?
Yeah.
And Judge,
I don't mean to interrupt your presentation, but I just wanted to kind of get that as obviously a baseline.
Certainly.
Thank you.
Thank you, Judge. Judge, do you want a second to review the score sheet before I continue?
Let me glance at it just a second. Okay.
Judge, he picked up these charges for which he's currently on probation. To remind the court, it's smuggling, contraband, possession of a controlled substance, false ID of law enforcement, DWLSR, and paraphernalia times 2. Judge, his first violation was in September 2022, and when he violated by having a DWLSR. So again, driving when he knows that he's HTO, he knows that in 2022, April of 2022, they revoked his license for 5 years, but he keeps driving, Judge. And so his first violation was a DWLSR, and for that he was placed on community control. Now, since being on community control, he made another decision, one that's more brazen, one that's more bold. He decided to steal a Hyundai from a gas station, and that is what he pled to, and that's what Mr. Gates was referencing. So for all of this and his priors, he scores 41.6 points. Now, I understand that the legislator's intention of the score sheet is to provide some kind of a guideline of what is an appropriate offer. However, the legislator has also made it clear that if you score over 22 points, you can go to the DOC, and it's the state's position that DOC is the proper place for this defendant. Judge, he can go and he should go. He's been making clear violations of his probation, and for that we believe 12-1 is the appropriate sanction, Judge. And also, I would like to make a point. This talk about him having to check in with probation again on the other charge that's in a different county for stealing the car, Judge, it's important to know he hasn't done well on probation at all. So that's not much of a sanction. And here,
so his probation is going to be in the other county on the other charge?
Yes, Your Honor.
That's correct, Judge. And so they might have made a decision there that probation is the proper outcome. But that doesn't mean that we need to make that decision here. I would present to the court that he has been given multiple bobs at this apple. He's been given multiple tries. And he continuously cannot stay on probation, and he's violating. He's not violating on technicalities. He's violating by picking up new criminal charges. It is time to go to DOC.
Mr.
Yes, Your Honor. I would point out, Your Honor, again, we got a score sheet for a reason. If we start sending people to prison because they score more than 22 points because they make a decision, I think we're going to end up with a prison full of people more than anything else, a clogged system. That's not what the score sheet is intended. That's not what they designed it for. I will correct the state. The state said it was a 5-year revocation. It's a misdemeanor, second-degree driving charge. It's a misdemeanor HTO. I don't think that includes a 5-year revocation. I would point out that for that charge, I think the statute now says it's a 10-day jail sentence. As far as the charge in Jackson County, the victim in that case was my client's uncle, his mom's brother. That's why that case was resolved the way it was. That's why he was given probation. Again, I just look at the totality of the case, and part of punishment is increasing punishment, which is why we're not asking the court to do time served. We're not saying 30 days, 60 days, 6 months. We're saying, look, we get it. We tried probation. It's just not ideal for Mr. Gray. We think that a 9 months is a next step up in the punishment, which would be an appropriate punishment here. The idea is really to keep Mr. Gray in the county jail setting so that when he does get released, we can potentially get him back to Jackson County pretty quickly to start that probation.
What's the advantage of, I understand that if you are over a year, you have to be in DOC.
Yes, sir.
But you're asking for 12-1, which is essentially a year. We could do that 11/29 in the county jail. I'm just interested in the reasoning, philosophical or practical or otherwise, why you're seeking DOC versus county court. Because it's not about the time, because it's only 12-1.
I'll let the state handle that, Your Honor.
Well,
That
I'm going to ask both of you.
Well, Judge, I'll tell you this. To Mr. Gates' point, he said that if we start sending people to DOC for scoring over 22, we're going to have a DOC full of people. Well, we already have an Okaloosa County Jail full of people, Judge. And this defendant is a hillbilly's heartbeat as far as points go from scoring.
He's what?
A hillbilly's heartbeat, Judge. He's close. And my point...
You're lucky not impressed.
Judge,
we're on Crestview TV.
my point is he's essentially almost there. And I should have picked another phrase, but my point remains, Judge. He is so close, and I believe that it's the appropriate resolution of this case.
And I'll give the opposite philosophical approach, Your Honor. I think a lot of this stems from a potential confusion regarding the county jail. I've had multiple conversations with the jail. I can tell the court, who I spoke with, the court wants to follow up. My conversation with the jail has always been their concern, safety concern deals with more people who've been there 3 years or longer. That's when they start presenting a very serious safety risk. And that's the conversation that was had recently about the jail crowding. When I asked them specifically about people who don't score in county jail sentences, the reaction was, no, we want people here on the county jail sentence. One, they get paid by the number of people in the county jail. Their funding is directly tied to it. So they would prefer to have people in the county jail for funding. Two, they also get paid for the...
That's novel. I'm not sure you get
And
universal agreement on that.
I'm just telling you, the upper person I talked with
Do they only
expressed...
get funded for after the sentence or pre-trial?
It's for people sentenced to the county jail, Your Honor.
So it's the sentence that gets the...
Yes, Your Honor. And they also get paid for the work.
I've never heard that argument.
Yes, Your Honor. And they also get paid for the work that the inmates do while they're at the county jail when they go out and do county work or wherever, that's also a source of income for the jail. The jail's pretty much told me they want people who don't score DOC to be in the county jail because it actually does help out with funding and other sources. The issue again I have is when we start just saying, hey, 22 points, you're going to go to prison without really giving much discretion, starts to be giving a mandatory situation. Obviously, Mr. Gray is at a point where he could score, which is why we're not asking to put him back on probation. If he scored more than 44 points, we wouldn't be here because it would be you scored DOC, you need to take the DOC and move on and do your time. Talking about a situation where he doesn't, where it's discretionary. I would point out that the original sentence was a withhold. When he was reinstated, it was a withhold. Both times the state saw fit to offer him a withhold and maintain the withhold. At this point, it's an argument really over how much incarceration is appropriate. Given what I feel is lack of criminal history as far as the felonies are concerned, and the score sheet, I think a county jail sentence is appropriate. Now, when we're talking about a difference of 12-1 or 11-29, I no clue. I know that there's a lot of people who think we serve more time or less time in DOC, you get your gain time, and I try to explain to them that's not how DOC works. DOC will only give you your gain time when you serve that month. You have to serve the month to get it. County jail gives it straight to you off the top. 5 days off the top the day you're sentenced. If you get into Blue Pod, you get an additional 5 days per month. So it's a little easier and quicker for people to get out of county jail, coupled with the fact that a lot of people are from the area, and it's easier for their family and friends to come up and see them at the county jail versus trying to schedule that at a DOC facility. I feel like with Mr. Gray, Your Honor, given the lack of the score, county jail is an appropriate sanction with him, and that's what we're asking for, Your Honor.
Well, first of all, thank you, both of y'all, for your arguments and trying to put a little different shade on it, nuances of these kind of things. These are important decisions, and the court wants to consider all the different perspectives, and I appreciate you doing that. Court does find that are you okay with this score sheet, counsel?
Yes, Your Honor. Mr. Gray and I talked about the only addition that he wasn't aware of was they included the grand theft auto from Jackson County, which bumped it up 2.4 points, I think.
So the court does, it is influenced by the lack of a minimum guideline sentence in this, although the court does acknowledge and have full discretion to sentence to DOC. And the court certainly take that into consideration. The court's just going to look at all the circumstances. I think everybody acknowledges, even the defense acknowledges, that there needs to be some punishment. And really, we're talking about a matter of months difference. The court is going to sentence the defendant to 11 months in the Okaloosa County Jail. You will get credit for time served. And with the probation already outstanding, the court doesn't find the need to burden the system with additional probation if he's already on 2 years probation on another charge. So we'll just allow this to go. He deserves to have punishment, 11 months in the county jail.
Thank you.
And
Cost. The standard cost.
Yes, Your Honor. Give Mr. Gray 24 months. He's on probation.
Yes.
Get that paid.
Yes.
Thank you, Your Honor.
probation is terminated.
And probation is terminated on these charges here in this county.
And that's all I have before the court, Your Honor. My name is Chris.
Thank you.
Thank you, Your Honor.
But that's all you got? Don't you have?
Yes, Your Honor. That was it.
Let me make sure it's out.
I will say if the court has more for me to do, I will be glad to stay.
Well, I've got you on Stephanie.
This is an adjudication this time, right, because it was withheld before.
Okay, I apologize. I did have one more. TJ skipped my one that I had.
The state would request to be in.
told me
Wait,
earlier.
wait, hold on. Thank you. Court is adjudicating.
And that, we were asking for that, Your Honor. We understood that was really part and parcel of that.
Okay. Thank you very much.
Yes, Your Honor.
Thank you, Madam Clerk.
We're ready for step 3.
You getting ready to leave? Had to call back in?
Yeah, I think we're going to take in this second reading.
Agreed?
Good. This is Miss Stephanie Green.
Yeah. That's probably clear.
Before the court, 22 CF 2557, 22 CF 2578, 23 CF 270. Ms. Green was originally noticed for a sentencing hearing, but after speaking with the state, we were able to negotiate a plea agreement for Ms. Green. Essentially, the state, 22, 23, agreed to reopen the last offer that was made to Ms. Green, which was a county jail sentence. Just make sure Ms. Green gets a chance to see the score sheet again, Your Honor. Your Honor, may I approach with the plea agreement and score sheet? And no objection to the score sheet, Your Honor.
Very good, thank you.
Thank you, Your Honor.
Would you please announce the agreement?
Yes, Your Honor. Ms. Green will be admitting the violation before the court in 22 CF 2557, 22 CF 2578, 23 CF 270, should be adjudicated guilty in all counts and cases. And 22 CF 2257, 11 months, 29 days in county jail concurrent with credit for all time served, $100 cost of prosecution, $150 defender fee. In case 22 CF, I have missed the 5, but it's 2578. Count 1, which is the second degree misdemeanor, 60 days in the county jail, credit for all time served, concurrent. Count 2, 11 months, 29 days, county jail, concurrent with credit for all time served. Standard cost of prosecution, public defender fee. And 23 CF 270, 11 months, 29 days in the county jail, concurrent with credit for all time served. Standard cost of prosecution, public defender fee. Ms. Green has asked for 24 months from release to pay all outstanding fees, Your Honor.
So are all of these concurrent with each other?
Yes, Your Honor.
So it's a total of 1129?
Yes, Your Honor.
Wanted to make sure, is that correct, Mr. State?
That's correct.
Okay. Very good. Ms. Green, would you please raise your right hand? You swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God.
Yes, sir.
So you heard your attorney state the terms of the plea agreement.
Yes, sir.
I'm going to summarize it. It's basically, you're going to get 1129 on all your misdemeanors, actually all of your cases, even your felony case. And then 60 days on the one case that's limited to 60 days.
Okay.
So those will all run concurrent, right? So there's a bunch of other stuff, though, in this plea agreement that you signed. Have you read this plea agreement?
Yes, sir.
And you've gone over it in detail with your attorney?
Yes, sir.
Because I want to make sure you know, you get a chance to go over all the legal questions that are related to this, because this doesn't include an incarcerative sentence.
Yes,
So
sir.
you understand importantly, you're waiving the right to go to a trial and contest all this by entering into this plea.
Yes, sir.
You believe that's in your best interest to do so.
Yes, sir.
And you've had all your legal questions answered. You feel like you've gotten good legal advice?
Absolutely.
Very good. Based upon that, the court will accept your plea, and the court will sentence you on the three of the 4 misdemeanors to 11 months, 29 days in jail, credit for time served, and the felony, same thing, 1129, county jail. All these are current. The 160-day misdemeanor will be credit for time served already. All these will run concurrent, so all run at the same time. You will get credit for time served, and then you do have, of course, always the additional fees and costs that are required. Those, you'll have 24 months from your release to pay before those go to release.
Yes, sir.
Okay? Any questions?
No, sir.
Good luck.
Thank you so much.
That does conclude my business.
Revoke and terminate probation, Your Honor? That is correct. Thank you.
Where's Mr. Eugene?
Your Honor, Justin M. Emery is back before the court in 23 MM 1150 this morning. Your Honor, I have spoken with Ms. Sharpless. We had discussed a possible plea and sentence agreement that was drafted, and then when I discussed it with Mr. Emery, I was not able to recommend it to him because of the possibility that as the case plays out, he would get a much better deal down the line potentially. I'm not promising anything, but I've then gone back and discussed with Ms. Sharpless the possibility in lieu of an agreement that he may not believe is in his best interest, a signature bond. And I have discussed that proposal with the state enough to try to explain what that signature bond would entail. Basically, whatever amount of signature bond the court felt was appropriate, with basically pretrial services and whatever conditions of a bond with pretrial services the court felt was appropriate, including drug testing and so forth. The one complicating factor that we were going to deal with under a plea and sentence agreement was a cross-reference over to 23 MM 2001, where he would be seeking modification to no violent contact. So what Ms. Sharpless and I discussed was that with respect to pretrial services and the way that we could word it is currently he is under a no contact in 23 MM 2001. So if the court would do a signature bond that said no contact, which shall automatically convert to no violent contact upon approval of that modification in 23 MM 2001, then by operation of law, they would be kept harmonious. And if he did go ahead and bond out tonight, prior to 23 MM 2001 being changed, he would know it was no contact. He'd have to go live with his mother, who I believe he would get housing with. Is that correct?
Yes, sir.
So he would not be in violation, but we could go kind of deal with it through normal protocols, and the county court could go ahead and issue its order of modification through normal processes. So other than the fact of having a automatic change from no contact to no violent contact, is a pretty, somewhat garden variety signature bond situation instead of a very onerous and somewhat weird global deal.
Your Honor, Mr. Medina and I did discuss that, and I think that is the best way to handle this, given that his client was reluctant to plead as charged, which was my suggestion, and he wanted more time to speak with Mr. Medina. Again, this was, you had to go back to court, remember, my victim was here, and she was pleading with me to do this. There is a financial situation at home that she does need help with, and she does believe that the defendant will seek his mental health and substance abuse treatment on the outside, and that this is not his normal behavior, Your Honor, and that if he does seek that help, that this will keep everyone's safety in check.
And so, give me a summarize again.
Yes.
Exactly what you're asking the court.
Yes, Your Honor.
And what the state has agreed to.
Yes, Your Honor. The first matter to begin with is what would the amount of the signature bond be, and his basically
What does the defense request? What does the state do?
yes. He was given no bond because of that new law in the misdemeanor case, so I wouldn't think that it's merely a matter of reinstating for the same amount. So I would think the court would probably want to have a relatively high signature bond. So I would say on the 2 felonies each, a $5,000 signature bond, and then on the 2 misdemeanors, another $1,000 each, so for a total of $12,000 signature bond. That would deal with that first issue. May I move on to other provisions? Pretrial services. No alcohol, no drugs except as prescribed. Mental health evaluation within 30 days of release, with any recommended treatment to commence within 60 days of release. Random urinalysis, substance abuse evaluation within 60 days of release, and commence any recommended drug-related treatment within 90 days of release. No contact with Sarah Ellis, and then there's 2 juveniles. I would list their initials, SD and NL. No violent, and then a proviso that no violent contact in 23 CF 1150 shall automatically convert, no contact in 23 CF 1150 will automatically or shall automatically convert to no violent contact when and if a modification to no violent contact was approved in 23 MM 2001.
Okay. Are the juveniles your kids?
No, sir, they're no children. We have one mutual all together.
Those 2 were the initials that were the alleged victims in the child abuse count 2, Your Honor.
So I don't see any reference to the child that's their child between.
I'm not sure what the facts were.
I just want to make sure we're covering all of our bases.
If you'll give me just a second.
It does say 3 juveniles. Do you know the initials of the 3 juveniles that were in the vehicle?
No, there was only 2 juveniles in the vehicle.
Those 2?
Yeah, they had
SD and NL. Okay, so it was incorrect when there was a reference to 3 juveniles in the paperwork.
Yes, okay.
And that's what I was about
But
to say.
there's a third child, he just said.
He said they have a child in
They have
common.
a child together, Your
And
Honor.
so is that just not a part of this?
Your Honor, I obviously don't object if we add that child in, but the other children were the subject of, the other children were actually in the car with their mother when this event occurred. That's why they're part of this case. There's,
What are their initials in
SD.
the one that you have together? Who wasn't in the car?
I think I would feel more comfortable if we added that child also. I think that's a good point.
Your Honor, we could add a third minor of LE initials. That's the child held in common between Miss Ellis and the defendant, correct?
Yeah.
Let me ask you one other question. Is the DCF involved?
Yes.
Yes.
Yes, and Your Honor, I'm sorry, I meant to, I had written in the agreement, but cooperate with DCF/FFN.
And they've taken over the investigation. They're,
And any, of course, the court has enormous experience in this area. Anything else that the court deemed appropriate, of course.
Well, I mean, normally, because they have more granular involvement with contact in these situations, generally what you want to do is have, and they've got hands-on, with case managers and everything, their contact, how can I say this, their recommendations as to the type of contact and what type of supervised, what are the terms of the contact, that we would defer to them because they have more, they have caseworkers and social workers and all that.
They have ordered that it be supervised between the mother and me. As long as she's around, I'm allowed to be around them. And as long as my mother's around, I'm allowed to be around them.
So just say that. What I would say is that the DCF, contact with the children would be based on the DCF work, which is kind of, and having done that, it sounds like they want you to be involved, and that's what a lot of people don't understand. They actually encourage that with certain type of supervision. Okay, so the state's okay with all that?
Well, Your Honor, I'm okay with the latter part of that as to the monetary obligations. I was gonna reiterate the monetary amounts that were imposed and just suggest that the court reduce them to a signature bond. So if there is a violation, the original conditions, well, obviously there'll be no bond, but just so that he knows.
What are the original, that's what I
So,
thought
Your Honor,
Mr. Medina said.
Yes, Your Honor, on count one, originally there was a $10,000 bond.
Oh, okay, I wasn't trying to reduce
I
things, I just couldn't find it in the
I
paperwork.
know. There's a $10,000 bond on count one. There was a $15,000 bond on count two, Your Honor.
Okay.
There was a ROR on count three, and there was a $5,000 cash professional bond on count four. I would ask that those be reimbursed, just reduced to a signature.
I'm sorry, yes, no objection, Your Honor. And he had one other question, Your Honor, may I confer?
You may.
No. Well, that's easy. Thank you. Nothing further, Your Honor.
So the court, based on essentially the stipulation of the parties, court will amend the bond to a signature bond based on the original terms. The original bond, they were cash or professional, those will all go to signature bond. So 10,000, 15 ROR, and 5,000 on the 4 counts. And in addition, there would be pretrial services, no alcohol, no drugs without prescription, mental health, random UAs, all these things you're dealing with over in the dependency arena too, I assume. And if you don't, they don't have a case plan. Do you actually formally have a quote unquote case plan? Have you heard that term?
With FFN?
Yeah.
Yes, sir.
Okay, so they're already getting you to
They're by the house, and they're
right
by my mom's house, all my kids.
But they'll also, they're going to want you to take some,
Yes, sir.
counseling or this and that. So, and then as it relates to no contact with the victim, Sarah Ellis, no violent contact. And then I agree with your wording, no contact with Sarah Ellis unless they can get the misdemeanor changed to a no violent contact, in which case it would change to a no violent contact.
Yes, Your Honor.
That's fine.
So
As
that's
it relates
that's
to the
just-
children, we're going to defer to DCF and any order in the dependency action, which is already in place, and it sounds very reasonable. So, is that all we need to do technically?
I think so. Madam Clerk may have a question, Your Honor.
Well, I just want to make sure that I have it right on the minute sheet.
Sure.
And I just go with pretrial services, no contact with victims or child in common unless allowed through DCF. No contact with victim unless allowed in 231150 and 2001. Mental health eval 3060 of release, substance abuse eval 6090 of release, random UAs, no alcohol, drugs without RX.
The provision with respect to no contact with Sarah Ellis, I don't know how you refer to it, but basically that would be unless no violent contact was allowed in 23 MM 2001. Okay, so it's going to change the no violent contact in 23 CF 1150 if it is changed in 23 MM 2001.
And I would slightly word a little different with the children. The contact with the children would just be governed by the dependency action.
Thank you,
Put
sir.
that in there. And this case will be resolved prior to that case being resolved. So that's not going to go out. That's going to take a little time to work at it. So one thing I'm going to say to you, and I didn't look at all what occurred here that led to this, all the allegations. These are some fairly serious bond amounts, so they must have been serious. You know, you've been in jail, you're clean.
Yes, sir.
When you're in jail, changes your personality. You need to pay attention to this and make sure and get the kind of counseling and stuff you need, because, you know, this will rear its head again
Yes, sir.
if you allow it to. And, you know, they talk about, you know, fentanyl being a terrible drug, and it is. It's a scourge of our society. It's killing more people. But you could make the argument that alcohol is more destructive than fentanyl because it's so wide use.
It is.
It's a deadly, addictive drug, and it affects different people different ways. And so you gotta exhibit some real strength to keep that away. If you want your family,
That's
you're gonna have to
my
figure out a
number
way to stay away from that.
That's my number one goal.
And Your Honor, with respect to Mr. Emery's no contact with Sarah Ellis right now, is that he needs to make sure that he stays in contact with my office, because if we find out that he's changed to no violent contact, we want to let him know, but I don't want him calling up Miss Ellis to see if it has been changed, because then he'd be maybe violating.
And your contact, and you know, somebody needs to talk to Miss Ellis, that, you know, if she calls you on the phone, guess who's in violation of the no contact order?
I understand, yes, sir.
Okay, it's one side, and it may be very innocent, but you gotta be real clear, you know, just really be cautious. You're gonna be able to get out, so, I mean, that's obviously a good thing. You can be with your mom, but give it some time in order to get the other thing where you can have the contact appropriately, and you can start seeing the kids and other things in a more positive fashion.
Yes, sir. Thank you, sir.
Your Honor, Miss Ellis does know that was a lesson learned from the misdemeanor case that ended up revoking his bond. She understands now that, you know, that no contact's going to be taken seriously, even if she tries to call because she's trying to get him to calm down or whatever is happening. She knows that there's going to be law enforcement contact, and she is taking that seriously, so she knows that everyone is just looking out for everyone's safety and making sure that, you know, this does not happen again, but she does want him out and want him healthy and to get healthy and well on the outside and work to get in a better situation together. So.
Good luck.
God bless. Thank you so much.
So that case is,
It doesn't matter either. sir.
Oh, the next court date, please.
Next court date?
Yes, sir.
Your Honor, October 9th.
October 9th.
I'm giving him my card. You can call my assistant when you get out. Okay?
Yes, sir.
Set an appointment.
Thank you so much.
Thank you.
Thank you, Your Honor.
We're doing Casey?
Whichever the court prefers, Your Honor. I'm ready to go for case and cloth.
Do you have pleas or?
No, Your Honor, they're not going to be pleased.
Straight up?
No, sir, they're...
They're
There
pleas
was
of
an
base.
Your Honor.
I just want to see if anything has changed.
Well, I need to report to the court that, because I just got...
Let's go ahead and make the announcement. Go
Okay,
ahead.
this is Steve Medina with Jimmy E. Case in 22 CF 1820. I got reassigned this case from my colleague. I am not prepared to go forward in a sentencing hearing today. I do want the court to be aware that I have informed Mr. Case as to the state's position. He has indicated to me that he thinks there's a conflict between himself and me relating to the plea that he entered on March 21st, 2023. And I'm not making any statements of agreement with what his position is, but I do think it presents a potential conflict between the public defender's office and Mr. Case. So even if I was prepared to go forward, which I'm not, because I've just received this case reassigned from someone else, I am not, I think, in the best position to do that because of his alleged assertion that there's a conflict. I think it would be better at this point to relieve the public defender and appoint RCC to represent. And he can elaborate what his position is that he thinks it's a conflict on if he wants to.
Well, let me ask you this. Do you think there's a conflict?
I think that there would be a conflict based on what he
If you
said.
believe that there's a conflict, I'll let you off.
I do believe there's a
If
conflict.
he believes there's a conflict, I have to check and see, because I may not agree with him, but if you do it, that's a little different.
I'm just trying to think. The posture is that he has given me information that would lead me to believe there is a conflict based on his assertion.
Okay. Okay. I'll substitute counsel then. You can get me another.
Unless he wanted to go without a lawyer, which I wouldn't recommend, but he would. So we will provide the paperwork for RCC in place of the public defender, Your Honor.
If your client wants to say something, don't
Yes.
talk about the case. Don't talk about any the substance of it. Because you're under. I'm going to put you under oath, and you're going to be recorded. It could hurt your case.
And just,
Yes, sir, I just had a question about when I was sentenced last time.
You
What
weren't
was said, something that was said in open court.
You were not sentenced.
No, sir, for the last charges, for these charges that I'm in here on.
Right. You entered a plea agreement, but it was a plea to the bench. You were not sentenced. That's what we were going to do today.
Yes, sir.
Right? You understand what I'm saying?
No, sir, not really.
Your Honor, I think he's referencing what might be the subject of the conflict. He pled out on the merits on the underlying case on March 21st, 2023. I was his lawyer at that time, and I think he might want to present testimony or something relating to the advice that he says I did or did not give him at that time.
It was something that the state had said after I was sentenced.
But in any event, the court has relieved the public.
He keeps saying he was sentenced. Is there another
No,
case?
I'm sorry. No.
You're saying when you entered into a plea agreement?
Yes, sir.
There's a plea to the bench.
Yes, sir.
But I'm not sure about the plea to the bench. The only agreement I know of was March 21st on the underlying case. Is the court referring that he had pled to the bench for purposes of the VOP that was the subject of today. And I don't have an agreement relating to that. I don't think the conflict related to his allegations pertaining to the March 21st when he originally pled out. is my understanding.
I don't know about that. So that's, if you know, that something has to be filed if you're addressing that. All we're addressing today is the plea to the bench on the VOP, basically the VOP sentencing. And we're going to substitute counsel and get you a new lawyer so that you can figure out how you want to proceed and get somebody to argue for you on that sentencing. Okay?
Yes, sir. Thank you.
Thank you. So,
Mr.
do
Cloud?
we have another hearing on that?
No, so we do not, we need to set one.
Okay, so let's set that for September 19th at 9 a.m.
Yes, sir, thank you. What was his next, Mr. Case's next court date?
September 19th at 9 a.m.
JJ, September 19th at 9 a.m.
Your Honor, Steve Medina with Sean. How do you pronounce your last? Plow?
Yes, sir.
In 22 CF 1265 and 22 CF 1266. Your Honor, this is also one where I guess we're here for sentencing, but I just got the files and I have not had an opportunity to meet with him. I do know that he was wanting to reinstate to community control or data house. I know that the state's position is guidelines, but if I'm understanding the posture that he must have pled to the bench, but I'm not privy to that situation.
He definitely pled to the bench, because I'm looking at the orders that said him that. And we had today's hearings, the sentencing. But if you just got the file.
I did just get the
you
file,
obviously
Your Honor.
can't represent him in due course. So.
And I must ask for a continuance. I hate to drag that out. I know that he says that he has Jada House. Is there any way to do it without having to have a contested sentencing? Is there any way to do the state is indicating no. So it is going to have to be reset for sentencing. May I have just a moment with him, Your Honor? Sorry.
Sure. What are guidelines on that?
In Mr. Clue's case, Your Honor, the guideline sentence would be 15 months.
Your Honor, I did meet with Mr. Clue enough to understand what the nature of his position is on sentencing, and I'm going to withdraw my request for continuance, and he's prepared to go forward with sentencing because it was only going to be his testimony about some situations, so I think he could go forward. So we will go forward.
Would you raise your right hand, Mr. Clue? Swear or affirm the information you're about to provide this court is the truth, and nothing but the truth, so help you God.
I do, sir.
Okay. I want you to make sure that you're clear. Do you want to proceed forward today?
Yes, sir.
Your attorney just said he just got this file in the last few days, hadn't really looked at it, talked with you for 2 minutes. You're going to make your argument.
Yes, sir.
I'm going to sentence you here today,
Yes, sir.
and I don't want buyer's remorse. Are you sure you want to proceed with this? Because you're going to be held to it. In other words, you know, if I give you a sentence you don't like, you go back and you're sitting in jail for a few months or a few years or whatever I give you, all of a sudden you're like, oh, I shouldn't have done that. You know, I should have let my attorney get up to speed so he could argue for me. Then you're saying he didn't give good legal counsel.
I understand.
I'm wary of this because it's critical the defendants get fair treatment. And one of the cornerstones of having a fair treatment is having access to legal counsel.
Yes, sir.
And so this is perilously close to you not getting that cornerstone. Not that Mr. Dees is a good lawyer, but if you just get the file.
Your Honor,
Wouldn't be able to argue as well as you might.
May I have another moment with him?
Yeah.
please?
The state's seeking guidelines?
Yes, Your Honor. That was the state's offer in this case.
Your Honor, what I'm inquiring, because based on the nature of the situation, there might be some possibility that I would want to call another witness or witnesses who are family members.
Certainly understand that.
And the fork in the road is that he's been in, I think you've been in jail, you turned yourself in, was it in May? May. So has his, they will take him back at Jada House, so he feels the urgency of the situation, but as the court is wisely stating, is you can't take a chance that that urgency will be dealt with in a way that you consider to be favorable or positive, and then it turns out not to be that way, and then, oh, if only. So,
Yeah, I mean, you have, and your attorney has explained to you the minimum guidelines. You know, that score sheet is a powerful element of this. Not the only element I have to consider, but it's a powerful element. It's saying you need some incarceration.
Your Honor, my understanding is there are no new law charges, so I don't think the court would be bound by that score sheet. I don't think there would have to be a downward departure to avoid incarceration. Am I correct? There's no new law that was part of this?
I don't know about the technical versus the new law issue. I know if the court were to reinstate, it does not need to do the score sheet. If the court is going to revoke and terminate and give a lower sentence than the score sheet calls for, it has to do with downward departure.
Basically, the court could structure it in a way that it wouldn't be incarceration, but wouldn't be necessarily.
Just to be clear, there may not be new law charges, but there are a slew of technical violations, so.
You want to weigh that opportunity and just go forward? You can't say it's only I wish that word. Somebody you think you can put me in touch with. Can't blame me. Okay, Your Honor, Mr. Clue represents, did I pronounce it right? Cloud represents that he's already made full efforts to contact friends, former employers, family members, and that there's nobody that he believes can be called in support of him in this situation, including his father, who is going through cancer treatment and cannot be called. So if he wants to go forward, I don't have any objection.
You want to go forward, Mr. Cloud?
Yes, sir.
Mr. Medina, you may.
Okay. Mr. Cloud. Yeah, I don't think.
Swear you, Mr. Cloud, if you raise your right hand, do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do. Yes, sir.
Okay, Mr. Cloud. What is your full name?
Sean Nelson Cloud.
Let's begin with something that you have advised me about. Did a close family member have a major medical problem since you went on probation in this case.
Yes.
Okay. You went on this probation in this case, when did you go on probation?
I think it was
June, was it June 14th of 2022?
June 14th, yes.
Okay. What family member is it that had the major medical problem?
My father.
And when did he have the major medical problem?
He had it right there in November, October, whenever I left jail.
Okay.
So, and I went to go back to Mobile. That's where I'm from, and I.
Okay, so you were, when you got out of jail pursuant to a sentence on June 14, 2022 in this case, you went and lived at Jada House?
Yes.
Okay. And did you remain at Jada House until October or?
October, right before Halloween.
Okay. And who was it that had a problem?
My father.
And where did he live?
He lives in Mobile.
What was the nature of his problem?
He had a massive heart attack.
Did you go to him in Mobile? Is that why you went?
Yes, sir. And then was helping him with his health problems, like to get him back forth and be there for him so he can deal with his health problems. Then whenever he got better, I came and turned myself in.
Did you have anybody else that could live with him and help him through that period of recuperation and so forth?
Not really. My mother, she's not real healthy enough to handle taking care of him because she barely can walk. So I had to be there for him.
Okay. You didn't have any siblings who were able to bear that responsibility?
No, my brother, he was out of town and nobody really could die. Well, I stayed there and helped him until he got better. Nobody showed up to really help him. They were busy working. I could take off for like 3 months to help him.
Okay. So, did you try to contact, we need to let this all come out, okay? Did you try to contact Officer Barras or anybody else with a probation officer about your dad's situation?
I did, and I asked for an interstate compact at the time, but that didn't fall through. She said, no, you can't leave the state, you can't do nothing. And then I called her and told her I was turning myself in.
Okay.
And whenever I came back to the area.
Okay. So, you left before Halloween in October. Did you know how far before Halloween?
I think it was like a week before.
Okay.
A week before Halloween.
Okay. And how quickly did you leave after you talked to Officer Barras, or were you already on the way?
I was already on the way because the health problem, I wanted to be there just because they told me my dad might not make it.
Okay. So when you got the call, was that like from your mother or from another family member?
From another family member.
Okay. And what was the nature of that call? It was like, Dad's in the hospital, or we need you, he's coming out of the hospital? What was it? Okay.
He's in the hospital. He's not going to make it.
May not make it. Okay. And fortunately, he did make it.
Yes. It took time, but fortunately, he started getting himself back.
And how many months were you living in the house with your dad and mom?
About February.
Okay.
And then I was working, and then I was trying to get some money up, and I was going to get an attorney to handle this, but I came and turned myself in instead. And then my dad really got better, and he's like, my boss said, go ahead and handle this because they're not allowing you on the job with my warrant for the probation violation, so I came and turned myself in.
Okay, now I'm going to have to flesh out some of that.
All right, so
Okay, that's all right. So, your dad was in serious recuperation mode till you got a job outside the house? About, when was that?
About February.
Okay.
You know,
And were you still in Mobile when you got this job?
yes,
Okay. What kind of job was it?
installing sprinkler systems.
Was it somebody you had worked with before?
Yes.
Okay. What was the name of that employer?
Southern, well, Travis Wilson is the employer, somebody I work for.
Okay.
Southside Services.
And was that in the Mobile area that you would do the work?
Yes.
Okay. And you remained living in the house when you weren't at work? You were helping your parents or what?
I stayed there for a few months, and then I had a little apartment. And then whenever I got money up, I started that's whenever I came in, my dad's health, I was taking him to doctors and stuff, and that's whenever I came back.
Okay. When did you get that apartment? When did you live with your parents and when did you get an apartment?
From February, right, February 8th, I stayed there on my own, at my own place. And
Okay.
And then, whenever my dad started getting better and everything, taking him back forth, I was staying, my boss said, hey, you need to go ahead and handle this in about, right, 2 days before I turned myself in.
Okay. And when was it that you turned yourself in?
May 15th.
May 15th. Okay. And why was your boss urging you to do that?
Because of payroll.
Okay.
Because he said payroll, he's had me on payroll and they were not taking taxes out. And he said, hey, I need you to go handle this and then come back and work for me. And
Okay.
I was planning on handling it before I was working, but work kind of got slowed
Mhm.
and compared myself with.
Now, hindsight's 20/20. You can't do anything to correct anything that the state is going to say you should have done better or different. But being fully honest with the court, now's the time to be fully honest with the court. You know, because people can understand coming to a parent who's maybe on their deathbed and helping your parents, but within your limitations and as a human being, is there anything that you know right now you want to tell the judge you know you were wrong on and you should have done better? Because let's be open with the court. You're not going to get any credit for covering up things.
I understand that I should have handled it a lot better by waiting to the probation officer and talk to the probation officer about me leaving before I left to go to Mobile. And I should have kept up the probation instead of violating by taking off.
Okay. Now, it looks like the paperwork is saying that you were instructed to report to the probation office on November 7th, and then on around November 15th, they were basically checking at Jade House, but you were gone.
Right.
Are you saying that you had let probation know before November 15th that you were going and where you were going?
I called there and talked to her, went by there, she wasn't in her office. And I called, and she came by a week before that, but she told me I had to wait for somebody to tell me I could leave. And then they're saying my dad was serious, so I took off.
So it was like this process of going through interstate compact that was going to maybe take a while.
It was going to take a while.
Okay, and you didn't really feel like you could
Wait. Just in case my dad didn't make it.
Okay, all right. Now, you do also acknowledge you did not complete outpatient treatment, is that correct?
I was doing it at the same time.
Through Jada House is your location?
I was going to that treatment and paying for another outpatient treatment.
What was the other outpatient treatment? Mental health?
No, it's like you pay $40. It's over there right next to the, I forgot the name of the building. It's been a while back, but I went to 2 treatments.
Okay.
And I was supposed to keep on continuing 5 treatments there, but that's whatever my dad had.
But you were living at Jada House and you were going to these, you think, 2 treatments?
Yeah, I was going to, they have
was it Bridgeway?
Right across from Bridgeway.
Okay. All right. Was that for drug and alcohol treatment?
Yes.
Okay. Was there another kind of treatment other than drug and alcohol treatment?
Basically, Jada, he said they didn't consider it being treatment.
Okay.
But taking the classes they have or at night meetings.
So where were the 2 treatments that you were supposed to go to?
I don't know the name of the building, I can't remember it, but.
They're 2 different buildings, were they near each other?
Yes, it's right near Bridgeway.
And they were sort of like different aspects of drug and alcohol treatment? Or they were different but similar?
It was like AA.
Okay.
Alcohol and drug treatment and how to deal with.
Okay. So were you doing that up until the time when your dad got sick and you went to Mobile?
Yes.
And then when you came back and reported, turned yourself in, that was into jail, or did you?
I turned myself into the jail.
To the jail, okay. And then anti-theft course, why didn't you complete that?
I didn't never get around to taking the anti-theft course.
And your probation you were supposed to do probation until June 13th, 2025. Are you aware of that? Okay. Now, did you remain, when you went on probation on June 14th, 2022, did you, other than these technical issues and absconding failure report that is subject to this VOP, were you using alcohol and drugs or doing anything that you weren't supposed to be doing?
I was staying sober the whole time.
Okay. Were you associating with people engaged in criminal activity or engaging in any criminal activity?
No.
Okay. Now, move beyond the lack of quality of my questions. This is your time to talk to the court, okay? What do you want the court to know about you or your situation in terms of, before we get to what we want to see happen? But what have I not asked you about that you really need to either confess to or acknowledge or address about the why you violated or any about the situation?
My dad was the reason why I violated. That was the only reason.
Okay.
And I mean, that'd be the only reason.
Okay. Now, in terms of what happens to you, would you like for the court to consider reinstating your supervision and allow you to go to Jada House, back to Jada House?
If the court decides on that.
Have you been in contact with Jada House enough to be able to represent to the court that they will take you back?
Before I turned myself in, I called Devin, and I've been keeping in touch, the guy that runs Jada House,
Uh-huh.
and he said I'm welcome back anytime.
Okay. And if the court wanted to consider releasing you to back to Jada House, would you be able to at Jada House do community control?
Yes, sir.
Would you wear a GPS? Would that be hard for you with work?
It probably would.
Would you work out in with water and stuff with sprinklers?
And then whenever I work in Fort Walton, there's a guy I work for, Don Wright, for the ring construction.
Oh,
So I get
ring
water.
construction, you're down in the water, okay. Well, I wanted to be open with what you think. What work could you agree to do that you, because you already know you need to do, if you got out, you need to start back with your drug and alcohol treatment, you need to start back with your anti-theft class.
I'll make sure I stay on top of that.
Okay. All right. Is there anything more you want to, the state gets to cross-examine you, is there anything more you want to tell the court or you want me to ask you about?
Nothing else.
All right. I'm going to turn you over.
Here, I don't have any questions for the defendant.
Okay.
At this time, the state would call Officer Doobie, though.
Well, let's see if he, I don't think Mr. Medina, but I need to ask him. I assume you don't have any other.
Nothing further, Your Honor.
Who do you wish to call?
Officer Doobie is in the courtroom now.
Okay. Mr. Medina, you want to sit down?
We're happy standing unless that's uncomfortable to the court.
I'm okay with
it.
it.
I don't want to try to.
The sharpest, you okay with that?
Yeah.
Sir, Madam Clerk, would you swear him in?
Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
Please be seated.
It's actually sometimes better if I stay at the table, Judge. I think you can see me better from the table than you can at the podium. Hi, Officer Doobie. Can you tell us your name for the record?
Yep, Paul Doobie.
And are you a probation officer with probation parole?
Yes, ma'am.
Okay. And was Mr. Clue on your probation load?
Yes.
Okay. Can you give us a little bit of history about why this evaluation report references Officer Veras, who also works for probation and parole?
Yes, Officer Veras was his officer up until October 31st. That's when I transferred back into this office from Escambia County, and he was reassigned to my caseload.
the witness has his mic right in front of him. I can't.
Sorry. Yes, ma'am. Is that better? Is this Kennedy? Okay, I'm sorry, I couldn't return your call.
Yeah, just slide that right in front of me, sorry.
So Officer, you were saying that Officer Perez, you took it over from Officer Perez, you transferred in from another office.
Correct.
So this November the 7th date that he was supposed to report, was that the first day you were supposed to meet with him?
Yes, it was.
Okay. And did he report to that scheduled office visit?
No, he did not.
Okay. So after that, what happened?
Then I began the process of attempting to contact Mr. Clough to get him to report. I was unable to reach him by any contact information he had left as far as his phone. And then I made several attempts to contact him through relatives and parents that he had listed in documentation. I was unable to get a hold of his parents. I did speak with his brother, who stated that he had no clue where his brother was at or how to get a hold of him. I also spoke with his sister, who stated that she didn't know where he was or how to contact him, but that she would attempt to contact her parents to get a hold of him so that he could contact me, so that we didn't have to go down the road of having a violation for his probation. I also went by Jada House, which was his last known listed residence, and I spoke with a representative at Jada House who stated that Mr. Clough had asked for a 2-day leave to go visit his son. They let him leave, and then he called during that time that he was gone and stated he would not be returning. He was going to be picking up his belongings and moving back to Mobile.
Okay. So at any time, did anyone inform you that defendant's father was sick?
No, never.
Okay. He mentioned, I think, speaking to Officer Veras about that, did Officer Veras leave you any notes that the defendant would like to start the intercompact process?
There is nothing in the file or in case notes that stated such.
If that was a conversation she had, would it be normal procedure for Officer Veras to leave those types of notes for the next probation officer?
Yes, it would.
Did you even attempt to talk to defendant's parents?
Yes, I did.
Okay. Were you able to talk to them?
I was not able to get through to the parents.
Is that when you talked to the sister?
Correct.
Okay. And then the sister said she would contact her parents and try to. At any point, did any family member tell you that defendant's father was sick?
No, at no point did anyone tell me that his father was sick.
Okay. And since June, when he was first placed on probation, had Officer Veras, was the anti-theft course and the other treatment a condition of his probation at that time?
It was a condition, yes.
So is it fair to say that he had from June to November to begin those things?
Yes, it is.
Okay. Your Honor, I don't have any other questions for Officer Doobie.
Officer, may I, Your Honor? Officer Doobie, because you stated the case was reassigned to you, but did Officer Veras have it from its initial inception? Was he her client from June 14, 2022 until on or about October 31, 2022?
I believe so, yes.
Her probationer? Okay. So you didn't have him previous?
No, sir, I did not.
Sorry, one moment. Officer Doobie, I'm sorry, Your Honor.
Or she came seeing other people.
Officer Doobie, in terms of what was input into the computer, have you reviewed that in relation to your testimony today? What's been put into the system in terms of probation notes and things like that?
Yes, sir, I have.
Did you specifically discuss with Ms. Varese whether he had ever discussed with her a interstate compact application process?
No.
Okay. I don't have anything further, Your Honor.
Your Honor, just one brief question. Officer Doobie, when a probationer requests interstate compact, there's paperwork and things that need to be done associated with that request. Is that correct?
Correct. And in an emergency situation, if a family member is ill, there's a proper process that a travel permit can be issued for out-of-state travel with the approval of the probation officer and the supervisor. And that's a simple request that can be made, knowing that the process for interstate compact transfers can take a while to go through and be approved.
So if there was a mention that a family member was ill, he could have requested a travel pass, and then interstate compact could have been started if he would have mentioned that his father was ill.
Correct.
Your Honor, I don't have any other questions for Officer Doobie.
Nothing further.
Officer, you may step in. Thank you.
Could I recall, when the state rests, I'll recall him.
Ms. Sharpless, any other witnesses?
Your Honor, I don't have any other witnesses.
Could I recall Mr. Clow?
Wow.
You're still on the road.
Yes, sir.
Mr. Clow, you heard what Officer Doobie testified to.
Yes.
Okay. Let me just start off by saying, did you in any way lie or misstate or give incorrect information to the court when you originally testified?
No, I did.
Okay. Because it sounded like Mr. Kevin Clow, who's your brother, had maybe some sort of contact, and maybe your sister had some sort of contact. Did you know anything about that?
They didn't say anything to me about it.
Okay. Were they around your dad during his recuperation and being sick in the hospital?
My younger sister was, but my brother, he was not. He was in Arkansas.
So is Kevin your brother?
Yes.
Okay. What about your other sister that was referenced? Was it Leslie? Is that this younger sister that was around?
Yes. No, I don't know why she wouldn't. I mean, she told me that probation officers called, but she didn't state anything that was going on.
Okay. Now, as far as
this is like 3 months later.
Okay. As far as contact during, let me ask one thing. Are you sure about that your dad's heart attack was before Halloween?
His heart attack, he had a heart attack, and he has other health problems behind all that. Yes, sir.
Okay.
And then now he has cancer.
Okay, but I'm asking about your belief that you needed to go to Mobile manifested before.
Yes.
But definitely before Halloween.
Yes, sir.
Okay. What did you hear about from Mr. Doobie that you could explain to the court a response about any of what he was saying?
don't have no sons, but I understand whenever he said, somebody said,
Okay, speak up.
somebody said I stated I had went back for my sons. I don't have any sons. I only have 4 daughters, which I mean, I stay in contact with them, but that wasn't the reason why I went back. But that was because Jada must have misinterpreted what I was doing, because I came back to get my stuff. I left after I talked to Perez, and I came back and I went and talked to her. She was there at Jada whenever I talked to her, so whenever she said I wouldn't be able to get an interstate compact stating.
Okay. So there's not necessarily an inconsistency with, you didn't actually start by filling out an interstate compact application,
Right,
is that
right.
correct?
Right, she said it takes a process and everything to get that done.
All right. Anything more you want to tell the court that would address it, the things that Officer Doobie addressed?
Yes, no, sir.
Nothing further. Your Honor.
Okay. State rest, defense is rested, you wish to make a closing argument? Mr. Medina.
Yes, Your Honor. Your Honor, I'm going to let Mr. Clue's words speak for himself. We're asking for a resolution that would not involve prison for somebody who was, from all appearances, doing well at Jada House. There's not the best clarity from the point of view of the situation of the officer saying one thing and Mr. Clue saying something dramatically different in terms of his family emergency. But I don't think that Mr. Clue was lying. That's obviously for the court to assess. There's a situation with this was his first violation.
Yes, sir.
There hadn't been any problems. He was doing fine in Jada House for, it looks like, 4 or so months. And I would ask the court to please allow him to reinstate and modify, to add his initial 12 months upon release to be served on community control. So 12 months of CC, and then serve out the remainder of his probation. And that it also be conditional on bars to bed, Jada House being available to provide him housing. Is the Jada House a period of Jada House, or is that an open-ended?
It's a 6-month outpatient program.
Okay. Would you,
Well,
how long would you go for a bed at Jada House if you went back?
You can go 6 months to a year.
Okay.
It's up to how long, like you finish the program in 6 months, but you can stay up to a year there.
Okay. Well, Your Honor, I would request that he be bars to bed Jada House for a minimum of 6 months. And if they can't provide housing for 6 months, then the bars to bed condition wouldn't be satisfied. So they'd have to confirm that they take you for 6 months. Nothing further, Your Honor.
Your Honor, before I start, would you like me to approach the bench and give you a copy of the score sheet in this case? Did I give you a copy? I might have given you a
No, go ahead. Might have been the prior. Yeah. You've seen this, Mr. McGee?
Yes, Your Honor. I think it's the same thing that was attached to your offer, wasn't it? Yeah.
Yes, it was.
Yeah.
Your Honor, the state's argument in this case, I think is very simple. If you'll look at the violation report, it appears that between 2016 and 2018 or 19, he was on probation in Escambia County for the grand theft and the uttering charge, which is listed as priors on the score sheet. Your Honor, a person who has been on probation previous to this probation term should know that if there is a medical emergency, they need to get in contact with their probation officer and ask their, even if they don't know about the travel pass, they should know to get in contact with their officer and find out what they need to do in order to get a travel pass to visit a sick relative. Your Honor, Officer Doobie testified that there were no notes left from Officer Varese about him calling, stating that father was sick. Officer Doobie received no communication that his father was sick. In fact, Officer Doobie's testimony is identical to what Officer Doobie put in the violation report, which is that when he called Jada House to find out what happened and why the defendant left, they told him that he said he was going to visit his son. Going to visit his state, telling Officer Doobie that he said he was going to visit his son is a very specific thing and very specific person and very different than his father is critically ill and he needed to leave. Those are two very different stories and two very different situations, Your Honor. I do think that there is enough inconsistency in what Mr. Clue says versus what Officer Doobie has testified to and what's in Officer Doobie's report, that the court should highly find Officer Doobie's testimony credible. And Your Honor, he has been on probation before. He was on probation previous to this for theft-related charges. Now he is on probation for 2 attempted burglaries of structures. Attempted burglary of a dwelling and an attempted burglary of a structure. Your Honor, these are more felony charges that he has given a second round of probation on and now has violated and was given a chance to make probation work for him by going to Jada House and having a stable place to live and address sobriety and his issues. And he left Jada House, did not report. In fact, I also think it should be taken in consideration that this all is supposed to have occurred in November, and Officer Doobie filed a violation and an affidavit in the end of November, and Mr. Clue wasn't picked up till February, or didn't turn himself into, not February, May. Did not turn himself in until May, Your Honor. So where was the communication between November and May about what was going on and trying to work something out with Officer Doobie, Your Honor? There was no testimony about that. So at this time, the state respectfully requests that the court find that Mr. Clue is no longer a good candidate for probation and that he should receive his guideline sentence. Thank you.
May I make a brief rebuttal? 2 points. Obviously, we don't have Mr. Devon from Jada House here to assess the particulars from his point of view. So the court can't assess and compare relative credibility on that issue and I'm not saying that Mr. Devon, we don't know about his accuracy of reflection of the conversations and so forth. The particulars cannot be scrutinized directly before the court. But what the second point I want to make is, I think, goes to the credit of Mr. Clow, and that is he did turn himself in. And the court is well aware of many people in these situations who don't turn themselves in. They eventually get picked up, maybe another charge or something like this. But he did turn himself in. He did try to come back forward and address the situation. He has talked to Jada House. Jada House, if it felt he wasn't a reliable person to live with them, wouldn't be accepting him back. And it can be dealt with, like I said, as a condition that he be bars to bed for a minimum of 6 months to live at Jada House. If they won't take him back because of his being unreliable, then he's not going to satisfy that condition. But he believes and he represents that it will be met. So I'll leave it at that. He did try to rectify the situation. He did not try to stay in contact enough. There's no question that he didn't do a good enough job about communicating during this period of time. I do know that the court, with a community control, which is house arrest, will be having eyes on in a way that will be very strict. And I think that he should be given that chance, Your Honor. Thank you.
So, Mr. Clode?
Yes, sir.
I don't know, I'm gonna start out by saying this, but you seem to be a nice guy. Nothing I'm gonna say here should take that away, but there's been some issues probably has to do with the drugs and whatnot. Let you hear that adds up to a lot of negative stuff on this paper.
Yes, sir.
And there's a little conflict about exactly how the absconding took place and why it took place, who told what. The bottom line from the court's perspective is there was not enough proof to overcome the minimum guidelines portion. That is a guiding principle in sentencing. And this instrument, with all the lines on it and everything, I'll take into account a lot of past history, apply numbers to it, a very sophisticated instrument. And while I don't always agree with it, certainly when there are difficult cases, I rely on it. And there's not enough information to overcome this. So the court is going to sentence the defendant to 15.15 months. He will get credit for all time served. I'm not going to order any probation beyond that. When you get out, you can get back to your life. And I do hope that you continue to try to find some assistance even while you're in prison to deal with your substance abuse. I mean, our court system, we're on the front lines of addiction and drug use in this country. And it's a scourge and it's difficult. And I'm not trying to down anybody, I'm just stating the fact it's difficult to address, and it takes you getting up every day to try to address it. I hope that you can do that as you proceed forward.
May I ask some clarifying questions, Your Honor?
Have a standard fees and costs. I'm sorry, Mr. Medina?
Oh, Your Honor, and I think it's implicit in what the court said, but I think it's a revoke and terminate.
That's correct.
And the court may wish to advise Mr. Clow about his appeal rights.
Yes, Mr. Clow, the court, you do have 30 days with which to appeal this sentence. So it's important for me to say that. You can understand you have that option.
Yes, sir.
Thank you, Your Honor.
Cox, hold on.
Just going to ask about monetaries to the judgment, Your Honor.
Yeah.
Your Honor, could he have 24 months upon release prior to monetary obligations going to collections or lien?
Your Honor, the state doesn't object to that.
That's fine. Court will order, allow them 24 months after being released in order to pay all outstanding fees and costs before they go to court.
And the cost, just for the record, I think it's probably $100 VOP fee times 2, and then a total of $250 public defender fees. Thank you. Thank you.
Very good.
Good luck.
Well, we're finishing up.
Thank you.
I think that was our last case, correct?
Yes, Your Honor.
You may.